Hello all. Welcome back to the Indian Patent Agent Examination video series by Pathways Consulting Solutions. Today, session 6, we will talk about Publication and Examination of Patent, Chapter 4. Publication and Examination of Patent. Section 11A, Publication of Patents. Now, so far we looked at what are the forms of applications of patent, what is a complete specification, what is a provisional specification, what are the contents of a specification. The next important aspect in understanding patent application is the concept of publication of patent. As we know that a patent is granted to an individual for public disclosure of his or her invention. Hence, it is important that an invention along with the best method of performing the invention has to be published, and the patent office facilitates the means of this publication. According to section 11A, a patent shall ordinarily not be available to public until and unless the prescribed period is expired. So, until the prescribed period of 18 months is expired, none of the patent related documents are to be available to the public for any kind of purposes. So, there is a strict secrecy that is maintained, and at the expiry of the 18th month, an automatic publication takes place with the patent office. So, the most important point is 18 month is the cutoff time, and after the 18th month an automatic publication of your invention happens and all public are given access to your patent document. Further, if for example an inventor wants to request for an early publication of the patent, in that case the applicant can file a request with the controller and ask for an early publication of the application. If so, the controller will agree to publish the application at the earliest possible date. Hence, an application can be filed any time after a patent is applied. However, for an automatic publication, 18-month period is the cutoff time. Now, what are the legal standing of a published patent application? The most important concept is every application shall be on the expiry of the specified period be published, that is after the end of 18th month. Now, in exception of cases such as where a secrecy direction is determined by the controller. Now, what is a secrecy direction? We will look at it in a separate chapter, but I will link those chapters when I talked about secrecy directions too. Or if an inventor does not want to proceed with the application, he can file for an abandonment of the invention. Now, why would an inventor want to do that? Say for example, an inventor has applied for a patent application and he realizes that his invention he is not able to provide the sufficient data or complete the experimental work. At the end of 18 months, instead of the application getting published, if he abandons the application, then that does not come into the public and he can further do his research and file another application. So, wherever an application is abandoned, that should not go into an automatic publication. Or if an application has been withdrawn 3 months prior to the period of publication. So, which means if you're withdrawing an application at the 15th month, then the application does not get published. So, the most important concept of this is 18-month period automatic publication happens. An applicant can request for an early publication as well. Those applications which are under secrecy direction or abandoned or it is withdrawn 3 months before the 18-month period do not get published. According to subsection 4 of section 11A, in case of a secrecy direction that is directed to a patent application, this subsection says that the application can be published only after the controller removing such a patent from the secrecy direction. Now, subsection 5 details about what are the segments that needs to be there in a publication, such as the date of the application, the unique application number, the name and address of the applicant along with an abstract and figure of abstract. Now further, upon publication, in case there has been any depository of biological sources such as those required for microorganism, etc. Now these depository institutions should make the deposit available to the public. Now the patent office may, on payment of such fees, may prescribe, provide the specification drawings or any such documentation also be available to the public. Now, what is the importance of a patent publication? On and from the date of a patent publication, the application gets all the rights, or the applicant has all the right as equivalent of a patent grant, except that he cannot initiate an infringement suit. So this is the importance of a patent publication. So reiterating the importance of publication, the rights and privileges of an application that gets published is the equivalent of an application that gets granted, except that the patent owner cannot initiate any proceedings of infringement until the patent has been granted. So that is what is being talked about in the publication of patent. Section 11b details about the request for examination. Now we just saw about publication, and we just saw that publication is an automated process. So by the end of 18th month, every patent application will and shall be published, except if it is withdrawn, if it is under secrecy direction, or if it is been abandoned. However, a request for examination is a process that wherein the applicant has to request. So no application shall be examined until a person makes an application for request for examination. And who are the persons who can file this request for examination? One is the applicant himself, or two is any other interested person. This is a very important point to be noted. So it is not the onus of only the applicant to file for a request for examination. If I feel that one of the patent that gets published is very similar to my product, and I want to know if that particular application will be granted, then I as an interested person can also file for a request for examination, so that the patent office looks at the request for examination, examines the patent and disposes it off at the earliest. So section 11b says that a request for examination can be filed by any person, that is an applicant or any other interested person, but within the prescribed time. Now the patent rules prescribes this time limit as 48 months. Now subsection 2 is repealed. Subsection 3 relates to section 5. So we'll move on to subsection 4. Now subsection 4 says, in case the applicant or any other interested person does not file an application for request for examination. So request for examination, if it is not filed, it is very important that the application will be treated as withdrawn. So there are no legal means wherein once you miss the deadline of 48 months, you can go back and get the application again in force. Hence, this deadline of 48 months is very important. So an application for examination has to be filed either by the applicant himself or by any other interested person. Now, subsections 1 and subsection 2 talks about, now if the applicant at any time after filing the application but before the grant of the patent is also eligible to withdraw the application by making a specific request. So even after filing a request for examination, he can still withdraw an application. Now in case wherein a secrecy direction has been issued under section 35, then the request for the examination should be made within that 48 months from the date of revocation of secrecy direction. So within the prescribed period for request for examination is 48 months. So any time before the expiry of that, but that time limit will start only after the revocation, which means the controller has removed the secrecy on that particular patent. So you have much more time. So these are the important rules of request for examination of a patent application. Section 12 talks about the examination of application. So now the process is after publication, and then the examination request is taken about, and a particular patent application is forwarded to an examiner, a patent examiner, for initiating the examination process. So when this particular examination process begins, it is the controller who marks an application to the examiner to initiate an examination report. It's called as a first examination report, FER, or it's called as simply a patent examination report. Now the examiner has to check certain grounds, prepare a report and send it back to the controller. Now what are the grounds in which a patent examiner examines? Now A, he has to check whether the specification and all other documents are in accordance with the requirements of this act. So the contents of a specification, whether timelines have been followed, whether a title has the prescribed 10 to 15 words, the drawings are in accordance with the sections, everything. So he checks if the specification and all other documents, including the forms, are in accordance with the Act. 2. Whether there are any lawful grounds of objections of the grant. Number 3. The results of the investigations made under section 13, which is basically anticipation. So is there any other documents that will prevent the grant of the patent? Now 4. Any other matters which may be prescribed under the Indian Patent Act and rules. Now he makes a report based on all of the above conditions are satisfied, and this report is ordinarily made to the controller within the prescribed time. Section 13 talks about search for anticipation by previous publication and by prior claim. This is one of the important sections where the examiner tends to analyze what kind of documents which is published can be used to anticipate whether an application is novel or inventive. So basically subsection 1, so 13.1 has two types of searches. One is a date after the filing date of the application and a date before the filing date of the application. So once the examiner gets an application that he has to examine, he notices the date of filing of that particular application. He files one search wherein he anticipates, wherein he looks at any kind of publications of patent applications in India on or after 1912, but this application which is talking about this patent in question, the invention has to be about the same or similar patent in question, but this has to be published before the date of the applicant's filing date. So this is called as anticipation by previous publication. I repeat again, wherein any publication which is published in any specification which is filed in India, wherein the publication date is before the filing date of the patent in question or the patent that is being examined. Now subsection B, so which is 13.1b, talks about any particular patent application wherein the invention in question is claimed, whereas that particular application is published on or after the filing date. However, that particular application has a priority date earlier than the filing date of the application in question. So this is to search, wherein you search for previous publication and you search for previous claim. So the examiner under section 13.1 looks for anticipation by previous publication in any Indian patent documents which is before the date of filing of the applicant's claim. He also looks for prior claim in any patent document after the filing, on or after the filing date of the applicant's claim, but the document claims an earlier priority. Furthermore, according to subsection 2, 13.2, not just in Indian patent documents, the examiner has to make all and any such investigation purporting to any publication of documents. So it can be a non-patent literature, which is a journal literature, or patents that is filed outside of India or anywhere, for any document that is published before the filing date. So subsection 13.1 A and B was looking at publication within the Indian documents, whereas subsection 13.2 says one more search where he not just has to look at the Indian patents published or claimed, he also has to look at any other patent documents or any other non-patent documents like journal literature, wherein the publication date is earlier than the date of filing of the patent in question, patent application in question. Now, one more subclause says that if there is an amended specification that has been filed by the applicant, then it is important that the examiner also conducts similar search for the amended specification the same way as he conducts the search for the original specification. The most important clause is the examination or investigation, anything that the examiner does on behalf of the controller or the patent office, they do not warrant any validity of any patent, and the central government, the patent officer or the examiner does not have any liability for any cases or proceedings that may arise out of this. Section 14 talks about consideration of report of examiner by the controller. So once the examiner has completed all the provisions of section 12 and 13, then he makes a report and sends it to the controller. If the examiner suggests that there are no adversaries and that a patent can be granted, then the controller initiates the proceedings for a grant of a patent. In case there has been an adverse thing that an application cannot be put for a patent grant because of an anticipation document or because of some corrections or amendments, then the controller sends the examination report to the applicant and gives him a timeline to reply to the examination report in form of an amendment or corrections or disclaimers, etc. Further, he also has to give him an opportunity of hearing before he disposes of the case. Section 15. Power of controller to refuse or require amendment in certain cases. Now, like in section 14, we saw the controller can request for an amendment or correction to the applicant. Now, the applicant can file an amendment and correction. It does not mean that once an applicant files an amendment that the controller has to accept the amendment if it is not in compliance with the provisions of this act. Hence, the controller has the power to accept an amendment, or he can also reject an amendment, or he can also request for an amendment. So if the applicant fails to do any of these, then the controller can refuse to grant the application. Power of controller to make orders respecting division of application. Like we looked up in one of the previous sessions, the divisional application can be filed if in case the controller feels that the application for patent can relate to more than one invention. So with the view to remedy the particular correction, the controller can request the applicant to file a divisional application, or it's called the further application. Now this further application has to be accompanied by a complete specification, but it has to be noted that such other complete specification should not include any matter that has been disclosed in the first application. So these two should be two separate applications originating out of a single application, and these shall not include the same claims or the same subject matter. Now the most important aspect is the controller also has the powers to require an applicant to remove or amend any such matter so that he ensures that for the same invention two patents are not being granted. That means the same invention is not being filed in the first application as well as the further application. Now there is an important aspect that the filing date and the examination of this divisional or the further application. The filing date shall be the same as that of the main application, but the request for filing has to be done within the same 48 months of the filing date of the application. So that has to be followed. Section 17. Power of controller to make orders respecting dating of application. So in a very positive note, in case there has been no prior anticipatory documents and an examiner issues a report saying that the applicant can be filed or granted, then there is one provision where an applicant can request to a controller for post dating of the application. This is only an exemplary statement, but in otherwise also an applicant has a standing where he can request the controller of post dating, that is moving the filing date of the application further ahead by 6 months. So in such an application, the controller has the power to move the date of the application, but it has to be noted that the post dating of the application cannot be more than 6 months. Now further, where an application or specification is required for any kind of amendment, then the date in which that particular amendment is complied with, or the date within which that the controller prescribes, should be the date before which that particular amendment has to be complied with for meeting the requirement. Hence, the dating of any particular procedure, be it a reply to an examination report, be it requiring a timeline for hearing submissions, anything has to be complied with as per the prescribed act and rules. With this, we come to the end of the slide where we talked about the publication and examination of patent, the criteria on which a patent shall be examined, the powers of controller with respect to the examinations, amendments and divisional application and post-dating of application. Thank you for listening in. Please leave in your queries or comments in the comment box below. Please stay subscribed in order to receive further series in the preparation of patent agent examination. Thank you.